Hi, everybody. It's Dave Stouse from Husch Blackwell. Thank you so much for joining us today for our latest webinar on the California Privacy Right Act regulations that just came in. Really happy to have you here today. We've got a lot to talk through, so we'll just kind of jump right in. These are our speakers today. It's me and it's Shelby Dolan. I think you guys know Shelby from prior webinars. What I will say is that those QR codes right there will take you to our LinkedIn profiles. We encourage you to use those, friend and follow us. If you're interested in this topic, we push a lot of content out on our blog, and we also push out on LinkedIn. And there you go. I'm done shamelessly plugging our LinkedIn profiles, at least for the minute. What I will say is they always ask me to do a bunch of introductory comments. I usually avoid many of them because I know you guys just want to get to the substance. There's buttons on your screen for the CLEs. If you're here for the CLEs, that's fine. Everybody needs CLEs. But there's a button on there to get you the information. And questions too, listen, I know there's a million questions on these CPRA regs. If you got them, throw them into the Q&A. We'll try to get to them. It's just Shelby and I. We'll do our best to weave them into our comments today. But if we don't, and we feel like at the end that we haven't hit the question that you've asked, we'll follow up via email. Okay, so digging in, I think if you've been on one of our prior webinars, you know that I like to start with a roadmap. Basically, that tells you where I'm going, so you can anticipate the various boxes here. Not really much mystery here. We're going to meander through the draft regulations and tell you guys the significance of what we see in those. We'll start with some takeaways, and we'll also start with the rulemaking process. I know top of mind for everybody, right, which is like the timing aspect of everything. What I will say, and I think is significant, is we're not going to hit every single change that's out there. If we did, we'd be here for 5 hours. You'd be bored, you'd turn me off, you'd hate me. We're going to talk about the ones that have, I think they're most notable. And we spend a lot of time, trying to go through and pick out the ones that we think are most notable. But there's certain sections as well, like verification, for example, really didn't change a lot. And so we're not going to rehash old stuff and talk about, sections that didn't change a ton. We have an hour, right, and we're already 3 minutes into it, and so we want to kind of move along and hit the high points. Okay, you get it. So let me get to the takeaway section first, and I've got 5 takeaways for you as we kind of jump into this. The first one I think is really the most important one to keep in mind. These are draft regulations, right? I'm going to show you some slides in a minute here to go through the Ccpa rulemaking process. That was the rulemaking process we went through a couple years ago. There were a lot of changes along the way. And so I think really what's important here is to grasp the concepts of what's going on with these regulations, not necessarily the specific verbiage, but understand like what additional things are going to have to be required if these hold true. And also like what are the topics that we're going to see a lot of comments on, right? And that's what we're really trying to bring value to today, to be able to talk through those things. Also, if you've looked at the regs, the draft regs already, you understand that they are a red line of the existing CCPA regulations. They call them CCPA regulations. And so this isn't like a wholesale rewrite of everything. They don't cover all 22 topics. The CPRA requires the CPPA to regulate on 22 different topics. This is not all of them. There are topics like cybersecurity audits and risk assessments and opting out of automated decision making. They're still yet to come. This is the first section of them. And I'll dig into the timeline in a second, but the pro-consumer nature of it really, you're going to see as we go through these topics here, it's a lot of pro-consumer information here. Okay, so what I'll say is I wanted to give you the resources because I imagine people are saying like, hey, I'd like to see the regs, I'd like to see the initial statement of reasons. These are QR codes that will get you to all of those. And if you grab the materials, which I think you can with an icon at the bottom of your screen, you can have access to all those. Okay, so the rulemaking process. This is where things stand right now. So yesterday, the CPPA, so the California Privacy Protection Agency, this new governmental agency that was just created with the CPRA, they had a board meeting. It is not happenstance that we are having this meeting that was intentional. We talked about it in a nutshell. They have not yet said the formal rulemaking process can commence. So that is to be determined. But what they did do, though, is they authorized the executive director, Mr. Sultani, to initiate the rulemaking process. So we're going to still anticipate getting the public period. We'll get the notice. That's all the con. You know, like the shotgun hasn't come yet on rulemaking. Okay. The draft regulations, they were presented to the board, and you know, the board voted in favor of moving forward with this process. So we're still waiting for the shotgun to go off, but we are at the start line, and we are just, you know, posturing to get ready with our run here. What I also should note is, and this is worth note, this is a monumental task. Okay, there's really no dispute that this is a huge undertaking by the CPPA. They are building the agency at the same time as they are coming up with the regulations, hiring people at the same time as they're doing all this as well. This is a really big task here, and everybody knows. I mean, you can say that the CPRA requires the regulations to come out, be finalized by July 1st. It's not happening. Everybody knows it's now. We haven't even started yet. So. Point being, you know, this is a work in progress here. The question then is, you know, when will these be finalized? When can we anticipate starting our compliance process? There was a lot of talk in the beginning of this process that Q3, Q4 was when they were, you know, looking to get these done. Doesn't look good for Q3. Obviously, we're in Q3. You know, the effective date of the CPRA still is January 1st, 2023. It's really difficult to anticipate when the reg is going to be done right now, but let's kind of talk about what we can focus on. This slide here, apologies, it's so small, but this is, you know, the regular rulemaking process. This is attached in some of the meeting exhibits for the agency meetings. There's a QR code that you can use there if you want to grab a larger version of it. And this is the same process that we use for California CCPA rulemaking process, the one that happened already. And so essentially how this process works is once the notice of rulemaking starts, there's going to be a 45-day period and a hearing. The agency is going to go back, look at the public comments, consider them, and determine whether to have a redraft of the regulation that come out. Depending on that process, there may be more rounds of changes. So if there are major changes to the regs, then they've got to go back to a 45-day period. If there are what they refer to here as substantial and sufficiently related, then there's a 15-day period. It's a 15-day comment period, and you see that process play out, right? So what we can't determine, and why there's a lot of ambiguity here, is we can't determine how many rounds of these are going to happen, right? And what I can say, and I think what's kind of useful, is to look at the CCPA rulemaking process. With the CCPA rulemaking process, and here it is, you sort of laid out left to right, right? You know, December 2019, and then October 2019 is when the original proposed regulation for those rulemaking. It takes from October 2019 until June 2020 until the Attorney General's office finally submits the regulations to the Office of Administrative Law. And note in the middle, they went through 2 different rounds of modified regulations. That's kind of what we can't figure out here, right? That's the unknown right here. But that process that the agency went through, the Attorney General's office went through, basically a 6.5-month process from what's coming out and those rulemaking out until it gets submitted to the Office of Administrative Law. And those those modified regulations, those day comment periods, not 45-day comment periods. So if you look at that and you say, okay, what if the CPRA regs follow a similar process? We're essentially looking at December, right, for that to be submitted to the Office of Administrative Law. And that's the process. So once the agency finishes the regulations, they have to submit it to the Office of Administrative Law to review and approve the regulations. The Office of Administrative Law has quarterly review processes, and so it's essentially, and I just got to note that I'm going in and out. Apologies for that. Let me try to get onto a different network here. Hopefully that improves things. So this process here is, what you need to do is you need to submit these regulations to the Office of Administrative Law in a quarterly process. And so if you submit those in a period of time between September 1st and November 30th, then the regulations would go into effect January 1st. The thing is, if they don't hit the November 30th deadline, then these won't be in effect January 1st, with one big caveat, which is when the CCPA regulations went into effect, they asked for expedited review June into August there. I know it's a lot of information, but this is all to say that this whole process is really going to play out over the next few months, and we're going to have to see how the time frame goes for all this. Last slide I give you, and then I'm going to turn it over to Shelby and see if I can't fix my audio here, is just looking at the effective dates, right? So when we look at the effective dates here, obviously the CPRA here goes into effect on January 1st, 2023, and Virginia does as well. So I think what I think what's worth keeping in mind is, we still have Virginia, right? We still have to make sure that Virginia happens and comply with Virginia. I do see a note here that says, the IAPP's report, the rulemaking process has begun. Yes, because there was a 4-0 vote to begin the rulemaking process. You need a formal notice of rulemaking process, and it can. I mean, that can happen today. That could happen at any minute now. So you'll get a notice of proposed rulemaking, and that will be the start. So for all intents and purposes, we're right at the start line. Okay, let me turn it over to Shelby and see if I can't fix my audio here.
Thanks, Dave. So we're going to start by diving into the regulations and looking at the restrictions on use and collection of personal information. Section 7002 is directed at operationalizing the requirement that a business's collection, use, retention, and sharing of PI shall be reasonably necessary and proportionate to achieve the purposes for collection and processing of that PI. So the regulations work to clarify what it means to be reasonably necessary and proportionate, and they state that the purpose must be consistent with what an average consumer would expect when PI was collected from them. This section also provides that the collection, use, retention, and sharing of PI may also be used for other disclosed purposes if those purposes are compatible with what is reasonably expected by the average consumer. So the regulations do include a number of illustrative examples for what is considered reasonably necessary and proportionate and what may be considered a compatible purpose. For example, the regulations provide that a mobile flashlight application, I will try to speak up if I'm coming in more quiet. The regulations provide that for a mobile flashlight application, collecting geolocation information would be an incompatible purpose for providing a flashlight service. So if that business wants to collect geolocation information, then it needs to receive explicit consent for that unrelated or incompatible purpose. So I'm going to turn it back to Dave. Hopefully your sound is better so that you can talk about consent a little bit more.
Yeah, thanks, Shelby. My suspicion is it's a platform issue at this point in time, since it seems like both of us. But be that as it may, I have my headset, so hopefully that moves things for us. Let's talk about this, right? So the topic here is screen, but methods of submitting requests and consent. This is a new section of the CPRA regulations. This is really, I think, it's a really interesting concept that they're driving after here. What they've essentially done is they've bundled the concepts of consent with design aspects of receiving requests. Okay, so if you look at the initial statement of reasons, because so just to back up there, we get the draft regulations, and then last week we get the initial statement of reasons. And the concept behind the initial statement of reasons is to fill in the blanks of why the regulations have been drafted in certain ways. And in some parts they do provide that information, and sometimes it's repetitive. But what you get from the initial statement of reasons when you read about this section of the regs
is it's all about dark patterns, right? It cites a number of dark pattern researches, papers from professors and other individuals, and it really hammers home this concept of ensuring that the way that can interact with your website and they interact with requests directed on your website, and the way that they provide consent aren't set up as dark patterns. This is interesting. It's worth noting that the CPRA talks about dark patterns only with respect to obtaining consent. It does not generally talk about dark patterns with respect to receipt. So this is, I think, it's an incremental but logical extension of what the CPRA is looking to do, but extending this concept of, consumer requests and making sure that those aren't dark patterns. And it says, the initial statement of reasons says that they're looking to hold businesses accountable for designing ways to discourage users from exercising their rights. Now, it's worth noting that consent under the CPRA plays a less prominent role than it does in Colorado, Virginia, and Connecticut laws. We had that consent to collect sensitive personal data. In California, consent is really set up as a means to circumvent consumer notice, right? So, for example, if a consumer opts out of sale, you can go back in and ask them to consent to sale. So there's a lot, point being, there's a lot of information on consent here and on methods of receiving requests, whereas, the CPRA really doesn't, in my mind at least, doesn't really hyper-focus on consent as compared to maybe like Colorado does. With respect to the way that they go about it, though, this is really different than GDPR, right? And if you look at guidance out of the European Data Protection Board, that guidance will go through and they'll say, okay, it's freely given. What does that mean? It's specific. What does that mean? It's informed. What does that mean? It's unambiguous. What does that mean? The California law pulls from GDPR for its definition of consent, but in the regulations, when it fleshes out what does consent mean, it does not use that same format. And that's not to say it's good or bad. It's just to observe the difference between those two. And it's worth noting as well that Colorado is going to be looking at this process. Colorado is engaged in rulemaking right now. They've identified consent as an issue. And so you can see, this idea of whether Colorado is going to match how California is going about doing it. And one more point I want to make before I move this on. Shelby just had in the previous slides, the last bullet point there on the previous slide talks about, they use the phrase explicit consent, right? And they use it 5 times in that section, right? So it's not happenstance. Explicit consent is, as those of us who are familiar with GDPR, explicit consent is a different concept than consent. It's a heightened form of consent. That seems to have gotten, sort of lost in the verbiage of the regulations, and I think it's one of those areas where they might seek to tighten that up in the next round of changes. So with respect to the boxes that we looked at here, just to go through a couple of these boxes, symmetry and choice is a real interesting one. Essentially what they're saying is, hey, you have to provide an equal path for the consumer to exercise their privacy protective option has to be the same as the path for them to exercise the less privacy protective option. And they give examples, and I've identified a few of them here in the text. But basically, hey, if you offer yes, you have to offer no, right? If you offer, yes, you can't just say yes and ask me later. If you have an accept all, then you must have a declined all, not a more information button. And so I know people are probably sitting there thinking, hey, this sounds a lot like cookie consent, and thinking about your cookie consent banners. And you're right to think about those things, right? I think that's really what some of these issues are driving after. And there's more to come on that issue. Let me just bookmark that. Manipulative language, then, really kind of fascinating aspect of these draft regulations. The concept here is they don't want, user interference. Hey, you can opt out of sale, or you can pay more money, right? Those types of choices, right? And we've all approached those while we're surfing the web. I've got one of them here. I pulled it right out of the regulations. I don't want to save money, right? We've all seen it, right? And so they're trying to regulate that. And again, this sort of incremental step of taking dark patterns, I think, a different way than what the statute actually says. Okay, I'm going to turn it back over to Shelby then to talk a little bit about privacy policies.
Yeah, so Section 7011 focuses on the requirements for the form, content, and posting of a privacy policy. So the regulations work to ensure that it is clear as to what the privacy policy needs to include and how a business should provide the privacy policy. So for posting requirements, the privacy policy needs to be posted online through a conspicuous link using the word privacy. For websites specifically, that link needs to appear in a similar manner as other links that the business uses on its homepage. So for example, the link should be the same font size and color as any of the other links on that homepage. For mobile applications, the link to the privacy policy must be in the settings menu, and it must be accessible through the app's platform page or download page. In its statement of reasons, the agency provided that requiring the inclusion of a link in the application settings menu is really necessary so that a consumer doesn't have to go searching around for that application's download page in order to access the privacy policy. So generally, the requirements are the same as before concerning what information needs to be provided in the privacy policy. It is important to note that the regulations actually reorganized these requirements into one section, and the agency stated that they did this so that businesses could actually treat it as a checklist when reading through the regulations, exactly what you need to include in that privacy policy. So just a few new requirements of note. A business needs to provide what information they're sharing and who they're sharing that information with. If a business uses or discloses sensitive personal information for non-designated purposes, of course, the privacy policy needs to include the new rights. And then, if applicable, a business needs to provide the contents of the different notices of right to opt out of sharing and the right to limit use of sensitive personal information. So overall, there's been quite a bit of commentary on the opt-out preference signal requirements, and Dave's going to dive into this issue a little later on. But for purposes of the privacy policy, it's important to note that the regulations now require these specific disclosures in the privacy policy under where you would place the data subject rights section in your privacy policy. So the regulations require the privacy policy to provide an explanation of how an opt-out preference signal will be processed, including, whether that signal applies to a device, a browser, a consumer account, or an offline sale, and then also how a consumer can use an opt-out preference signal. And then if the business processes opt-out preference signals in a frictionless manner, the privacy policy must also provide information on how a consumer can implement that opt-out preference signal. Again, Dave's going to dive into this and what frictionless manner means in a little bit, but those are the main requirements for the privacy policy disclosures. So next, I'm going to touch on some of the other notices that need to be provided. The CPRA requires 4 types of notices: notice at collection, notice of right to opt out of sales sharing, notice of right to limit use of sensitive PI, and notice of financial incentive. We're going to walk through the first 3 notices. We're not going to touch on the notice of financial incentive because the regulations did not make significant changes to that type of notice. So notice at collection. The CPRA requires businesses that control the collection of consumers' PI to provide consumers with a notice at or before the time they collect that personal information. If a business collects personal information from a consumer online, the notice at collection may be given to the consumer by providing a link that takes the consumer directly to that specific section within the privacy policy we just talked about. However, the regulations revised this section to make it very clear that directing the consumer to the beginning of a privacy policy or to another section of the privacy policy, in either case where a consumer would need to scroll through other information, that will not meet this standard. So in terms of location for this notice, for online collection, the business may post a conspicuous link on the introductory page and on any pages where PI is being collected. If a business is using a web form, they could provide a link next to the fields in which a consumer is inserting information, or a button where a consumer might submit info. For mobile applications, again, we're going to want to see that in the download page and within the app, such as in that settings menu I mentioned earlier. For offline collection, businesses can include a notice on a printed form or signage. And then for telephone collection, a business can provide the notice orally. So a few new content requirements for this notice at collections. A business needs to include a list of categories of sensitive PI collected, the purposes for collecting that sensitive PI, and whether it is sold or shared. If the business is sharing information, it needs to provide that. A new data retention requirement, including the length of time the business intends to retain each category of personal information, or if that isn't possible, the criteria used to determine the time period. If applicable, the business needs to include that link to the notice of right to opt out of sale or sharing. And then if a business allows a third party to control collection of PI, that business needs to also include the names of all of those third parties. So I'm actually going to talk about this new requirement a little bit more. Under this section, if a first party allows a third party to control collection of information, both the first and third parties must provide a notice of collection. So the first party must include in its notice the names of the third parties, and alternatively, if business does not want to provide the names, it can provide information about its business practices, that third party's business practices to include. The agency noted in its statement of reasons that this new requirement gives consumers all of the information that is necessary for them to make a decision about whether they want to interact with that business. The agency provided that this should not be an issue since businesses are required to enter into contracts with third parties and should be able to identify all of the third parties that control the collection of PI without any burden. And in addition, they provided that the option to provide information about third-party business practices rather than those names provides enough flexibility. So I have an example here of what this relationship kind of looks like. And so Business S allows Business G, an analytics business, to collect PI through Business S website. So Business S needs to provide a conspicuous link to its notice of collection, either identifying Business G or identifying Business G's information practices. And then Business G also needs to provide that notice at collection on its homepage. And so this is kind of one of those new requirements that really needs to be considered for the notice at collection. And so now I'm going to pass it back to Dave to cover the other two notices that I mentioned before starting this section.
Yeah, thanks, Shelby. And you know, I'm going to actually just turn the page back for a second there, right? Because I just find this one to be really kind of interesting in the sense that, you know, they call it Business G, an analytics business, right? I mean, why don't we just call it Google Analytics, right? I don't think it's happenstance that they picked Business G for this example, I guess is the point. It's, yeah, maybe I'm the only one who sees it in there. But being the case, I mean, to sort of turn the page on the next issue then, Shelby noted there's four notices, and notice of right to opt out of sale and share is the next one we'll talk about. You know, when you look at this one, we're all familiar with, would anticipate we're all familiar with the do not sell my personal information link now, right? How that's changing is obviously the CPRA has created a new definition, new term, I should say, called sharing, which is, you know, cross-contextual behavioral advertising, right? You know, we all know what sell is. It's the transfer of personal information for monetary or other valuable consideration. Now sharing is going to be, you know, cross-contextual behavioral advertising, right? So they've taken that out, put it into its own box. Be that as it may, though, they've you know, kept them logically joined here in this link that they're going to require entities to provide. And, you know, when do you need to provide it? Fairly simple. You provide it if you are, in fact, selling or sharing personal information. There's more information about where they want you to put the link in the header or the footer. I think, you know, this is the way it's done anyway. And then they fleshed out some of these issues about, how does the link work? And they want it to either immediately opt the consumer out or to take them to a web page where they can opt out. And as Shelby noted, and I'm going to have a slide in a second here, I mean, they've got some options there on that web page. There is, and we'll have a slide in a couple of seconds here, these exceptions I have down below. One's the alternative opt-out, and dive into that. And the other one is if you process opt-out preference signals in a frictionless manner. We keep on, talking about friction and frictionless, and you're probably wondering what it is. Just to tell you, we'll get to it. There's only so much, we can dig into every single slide, but this concept of like friction and frictionless processing of opt-out signals is something they've created new here. What they said here was in the initial statement of reasons when they were talking about this, they said this revision allows businesses to execute the consumer's right to opt out of sales/sharing with one click, which some businesses are already doing, and gives deference to businesses to craft their methods to opt out so they are easily accessible to consumers. So they view these changes as benefiting businesses and consumers as well. Okay, the notice, when is it required? Again, it's required if you sell or share personal information. The location of this as well, it's got to be provided on the web page. The notice itself, I should say, right? So you have the link, and the link then takes you to the notice, right? And so the notice has to be provided at the web page after you click on that link, unless it was done automatically. The opt-out was done automatically. That's the concept. And Shelby mentioned, that second bullet point under location there. Shelby mentioned that as well in her remarks about the previous notice. But it's really worth sort of emphasizing. This is nothing new in these regulations. The CCPA regulations say, hey, if you're going to use like your privacy policy as the means of providing the notice to people, that's okay, but you have to take people to a specific section of your privacy policy. So that's already part of the regulations that we're under right now. But they've said this a number of times here. They say, we mean it, is basically what they're saying in the initial statement of reasons and the regulations. Like, we really do mean it. And they say it's a dark pattern if you take people to the top of your privacy policy and then you have to have them like trying to push through, right, and define where the notices are. So like those anchor links are really getting reaffirmed in these draft regulations. For offline collection, phone calls, connected devices, they're throwing in TVs and smartwatches and virtual reality, all those types of things. One thing that's really kind of notable, I think, on this issue is for phone calls, the existing CCPA regulations say that you may provide the notice orally during a call. The new draft regulations say that you shall provide it on a phone call. I saw that one, and I thought of a million use cases as we talk with clients over the past 2 years. We're really going to wait to see how that plays out in the rulemaking process here and see if that sticks. Okay, the notice contents, nothing really, out of the ordinary here. You've got to describe the right. You have to provide instructions for submitting the request. And if it's online, you have to provide an interactive form for people to be processing those requests. I think those things are fairly, commonplace nowadays. So I didn't really see a ton in there that kind of think that upset the apple cart, so to speak. So this is the third notice then that we're going to talk about. And Shelby mentioned we're not going to get into the notice of financial incentive because of minor changes there. But this is new, right? This is the right to limit use of sensitive personal information. So just to kind of give you the backdrop here in case you're not familiar with it, sensitive personal information does not exist as a concept in the CCPA. It is a concept in the CPRA, right? We wrote a full article on how all these different state laws deal with sensitive personal information. You can find it on our blog if you want to dig in and get more information on this. We did a real comparison on how this approach is. If you're looking at like the Colorado, Virginia, Connecticut approach, then that's going to be consent to collect sensitive personal data, okay? California is different, right? California is you're allowed to use sensitive personal information if you keep your uses to certain designated purposes, okay? There are designated purposes, and I've come up with this designated language. I will say somebody else. But at the end of the day, it's sensitive information for X, Y, and Z purposes, right? And then it says to the agency, it says, well, you can come up with more purposes if you so choose, right, through your rulemaking process. They did that. They came up with those purposes. And what they did was they provided a list, what they call is a complete list of the purposes for which you can process sensitive personal information, right? And there's 7 of them. Obviously, I put it in the title. I've had them identified over the next 3 slides. I'm not going to, read every single purpose to you. I think we'll just hit the highlights real quickly. But here's the point, right, is if you're keeping yourself within these 7 designated purposes of the processing of sensitive personal information, then you do not have to provide the right to limit, right, because there'd be nothing to limit you to. The idea behind the, exercising the right to limit is to pull you back to these 7 purposes. Okay, probably belabored the point there a little bit, but, just diving into the 7 purposes, I think these are all, intuitive. Number 2 there, detect security incidents. I've got number 3 is, resist improper conduct, but as you can see, it's, resist malicious, deceptive, fraudulent, illegal actions, those types of things, right? It makes sense. Moving on, the number 4, ensure physical safety. Again, this is, something that's really existing in privacy law, that we don't want to let privacy regulations get in the way of actually saving people's lives. That is a good thing to do, right? Short-term transient use, you see that a lot too in CCPA and the CPRA, and even in other privacy laws like in Colorado and Virginia and Connecticut, this concept of, short-term transient use, right? Those types of aspects of processing sensitive personal information. And then, designated purposes, 6 and 7 here, perform services on behalf of the business, and then service or device related. Now, what I'll say is I've got the regulations and the bullet points there. If you were very interested in this, and I think that, over the course of the next few months, many of our clients are going to be very interested in exactly what's put here. There are examples provided in the regulations themselves. If I would have put them there, it would have, really extended the amount of text here, and I didn't want to do that. But be cognizant of the fact that you can go into the regulations and many times find illustrative examples that are attached to this. And I should say, and I was remiss, I meant to say it a little bit earlier in my comments, the agency did a really good job of providing examples in these draft regulations. The examples tend to be incredible. One on third party and the notice. Actually, there are many examples to be drawn from in these draft regulations. Incredibly helpful, and sort of giving credit where credit's due in that aspect. Okay, so moving along then, as far as you've got these 7 purposes. What happens if you stray and you start processing sensitive data for other purposes? Well, no surprise, you're going to have to provide that link, and you're going to have to allow people to limit you back down to your use of sensitive personal information to those designated purposes. And then if you do the rest of it looks the same as the opt-out of sell/share, with one big caveat. What you do not see here is in the exception section, you do not see any discussion of the opt-out signal, right? So in the sell share, it said, hey, if you're processing opt-out signals in a frictionless manner, then that's one of the exceptions. When you dig into the regs and you dig into the initial statement of reasons, what they essentially say is there is this concept where you can use signals to effectuate this right. But what they say, and I think it's accurate, is we don't have it yet. It doesn't exist. The technology doesn't exist yet. So they're not requiring or setting up as an exemption the recognition of limit my sensitive personal information, opt-out preference signals, for lack of a better terminology. I think you get it, right? It's missing here, but it's in the cell share. Okay. Moving on, as far as, when required, again, we talked about this already. If you're using it for non-designated purposes, the location, it's all very similar to the opt-out of sell and share and the notices. It's good. It's good that you see consistency along these notices. And again, that concept of you can't just point people to a privacy policy, you have to point people to a specific section of the privacy policy. Not new, but it is, certainly something that the agency is reaffirming here. Okay. Notice contents. Again, it's a new regulation. All of this limit the use of semi-sensitive data is new. But having said that, this stuff all makes intuitive sense. You have to describe the consumer's right, provide instructions for submitting a request, and if it's online, provide that in the form. Web forms are here to stay. Going to have regulations using the form. Web. Okay. As far as alternative opt-out link, sort of turning the page here, we mentioned this before, right? And this is really, in my mind, it's in the CPRA statute itself, this idea of, hey, we recognize that we're making you have not sell or share link, and we're recognizing that we're making you have a limit the use of sensitive information link. And what they say is, as an alternative to that, you can just use one link, okay? And then they say, the agency will be charged with figuring out what that alternative link would look like. And they do in these drafts. Tell you what that alternative box there, title. You must title the link your California privacy and limit the use of sensitive information links. So you have one link instead of two. So you would have to provide an icon to the left or right of the link. And so if you were wondering, and I don't know why you would be, but if you were wondering about, whether or not that opt-out button is staying in the regulations, it is. They've just moved it, and they're making it part of this alternative opt-out link. Okay. And then the last one there, the web page, the link, again, this concept that we've been talking about a bunch now, the link must direct to the web page where the description of rights and the methods to exercise them. One thing to sort of dive into then, because I know if you're like me, started thinking a lot about how this concept of that link and the Your Privacy, the California, how's that going to work with the other state privacy laws that we have out there? And so what I thought would be useful for you is to just have the text of these other ones, Colorado, Connecticut, and Virginia, being held in this space. And you could use the Your Privacy Rights, could you do that to satisfy Colorado, Connecticut, and Virginia? Connecticut we're not going to have rulemaking. In Colorado, we will have rulemaking, so we might get more to come on Colorado on this issue. But I think at first blush, when you look at this, if you look at Colorado here, it says the controller, which is the CCPA business, has to provide an opt-out method clearly and conspicuously in a privacy notice required to be provided to consumers and in a clear, conspicuous, and readily accessible location outside the privacy notice. So I think the hope is that when the Colorado Attorney General's office issues its regulations on this issue, that they accept the Your Privacy Rights, methodology from California as a way for you to actually effectuate your Colorado privacy rights as well, and we can throw Connecticut into that box as well. I think it only benefits consumers to have less rights, or I'm sorry, less links on the web page. It always benefits them to have more rights, I should say. No, it benefits them to have less links, I think, on the web page. I think confusion can definitely generate if you have multiple links and confusing links, and you click on one link thinking it's you, but that goes to California and you're in Colorado, and you have a different link and that goes to Colorado and you're in vice versa. I mean, I just think that really this is one of those issues where hopefully we can get rulemaking alignment so that we can really cut down on the number of links that we're going to have people click on. I was optimistic and maybe incorrectly so, that perhaps we could move towards privacy centers in this country. So you could click on a button at the bottom of the website footer that's a privacy center, and that would take you to an option that could have explanations of rights and all those types of things. I just don't know that we're going to get there with the way California is approaching it. But I am optimistic in how this all shakes out, that we will have, a way for us to hopefully be able to align these various links, because let's just, admit it. I mean, there's only so much room on a website, right? And there's some other issues too that they're about to talk about that are going to really, give you concern over user experience. Okay, enough about links. Let me turn it back over to Shelby, and she can talk about responding to consumer requests.
Yep, so turning to responding to consumer requests, section 7020 through 24 cover methods for submitting requests to delete, correct, and no. The regulations revise these sections to apply existing methods for requests to delete and no to the new right to correct. So, like I said, the CPRA consolidated requirements for the types of methods for receiving requests to be the same for requests to delete, correct, and no. For a business that operates exclusively online, the business only needs to provide an email address for receiving a request. For all other businesses, they must provide 2 or more methods for receiving a request. One of those methods must include a toll-free number, and if the business maintains a website, the method for submitting a request through the website also must be present, so like a web form. So timelines for responding to requests. Again, the regulations updated these timelines so that they align for all data subject requests, including the new right to correct. So for any request to delete, correct, or no, a business will have 10 business days to confirm receipt of the request and 45 calendar days to respond to that request. So request to delete. The CPRA places new obligations on businesses, service providers, contractors, and third parties for request to delete. A business that receives a request to delete now must notify any service provider or contractor of this request, and those service providers and contractors must also delete that personal information of the consumer. And the service providers and contractors must also notify any of its own service providers and contractors to also process that request. In addition to service providers and contractors, businesses must also notify any third parties to whom the business has sold or shared PI with, so that those third parties can also delete the information. Now, there is this caveat that a business does not need to notify a third party if it is impossible or involves a disproportionate effort. So the regulation defines a disproportionate effort as if the time and the resources expended by the business to respond to the request significantly outweigh the benefit provided to the consumer by responding to the request, then that's going to be that disproportionate effort. So it's important to note that the regulations do state that a business that has failed to put in place adequate processes to comply with consumer requests can't then use this disproportionate effort claim. Also, if a business does claim that notifying third parties is impossible or involves disproportionate effort, the business still must provide an explanation to the consumer. So request to correct. Section 7023 operationalizes responding to these requests. The first step is going to be determining the accuracy of the PI, and the regulations state that businesses should consider the totality of circumstances relating to the contested PI. So businesses may deny the request if they determine that the contested PI is more likely than not to be accurate based on the totality of circumstances. So what factors to consider when making that determination: the nature of the PI, how the business obtained it, and any documentation relating to the accuracy of the information, whether that documentation is provided by the consumer, the business, or another source. It is important to note that businesses are required to review, accept, and consider any documentation it receives from a consumer. The purpose of this is to allow consumers to provide their own sort of evidence of inaccuracy. So processing requests. If a business determines that the information is inaccurate, then they must correct the PI and ensure that it remains corrected. And similar to the request to delete, they also need to instruct all service providers and contractors that maintain PI to correct the information as well. Now, there is an alternative that a business may delete the PI instead of correcting the PI if the deletion does not negatively impact the consumer or the consumer consent to this deletion. So some of the different responses to a request to correct. If a business must inform a consumer whether or not it has complied with the request. If the business denies the request, they must provide the consumer with an explanation of that denial and also provide the consumer with the option of requiring that business to note internally and externally to onward recipients that the PI is contested. If the business received the contested information from a different source, the business needs to provide the consumer with that source's name, and then upon request, a business also needs to disclose information to allow the consumer to confirm correction, if, like I said, if they request. So I'm going to pass it back to Dave to discuss responding to opt-out of sales and share requests.
Yeah, thanks, Shelby. So, this is sort of the second part of the notice discussion that we just had, right? So you have to provide the notices, and this is, how you actually have to receive the request in the door, right? So what I think is, we've got some bullet points there, and I think a lot of this here will be intuitive to you. But the one at the bottom, I think really is something that I think is going to be subject to a lot of comments in the rulemaking process, and we'll kind of see how this plays out. But they've taken this position that the use of a cookie management tool is not in and of itself an acceptable method for submitting requests to opt out of sale and share. And they say in the initial statement of reasons, they basically say, hey, Privacy World has it wrong, right? The people are using this, and we've seen people using this as a methodology to do so, and we think that is incorrect. This is one of those areas where I think we just need to have a little patience and see how it plays out in the rulemaking process. I think there's a lot to get on this issue, but it is worth noting that they are really addressing what is a really fascinating type of an issue here. Processing the request. So there's new obligations if you receive this opt-out request about pushing this down to third parties. Okay, and so this is in regulation. I don't have to get into it too much. What I will say is that second bullet point there, if the third parties collect personal information on business's behalf or jointly with the business, you have to notify those third parties and direct them to comply. That to me, when I read the regulation itself, was not intuitive in what the regulation text says. But then if you go to the initial statement of reasons, I think it clarifies what they're getting after. So again, one of those areas where I wouldn't be surprised if we saw some revisions in the way that they're approaching the language there. But the takeaway here is, you're going to be, really, pushing down these requests, and part of that's already part of the CCPA as well. But something that's not is the next one, confirming the processing of the request. So the first bullet point there says, businesses must provide means by which a consumer can confirm that the request to opt out of sale and sharing has been processed, right? So this is something, when you look at the initial statement of reasons, they really make a big deal about this being a trend. And thought a lot about this idea of making sure that businesses are confirming that they've received and processed this opt-out request. What I find fascinating, and I think is going to be really part of the comment period, is this for example they give, right? And they use the word may, so this is not a shall, but for example, a business may display on its website consumer opted out of sale/sharing, or display through toggle or radio button that the consumer has opted out of the sale. There is, when we start thinking through this, right, we've got all these links that are going to be on the website, and now we've got all of these notices on the website, and now we've got this concept of, having to confirm processing, and things are going to pop up when you hit the website. And this is all to say, like, we're not trying to solve this issue right now, right? I think this is all going to be part of this comment period, but this is very pro-consumer stuff and stuff that businesses, frankly, are going to have to look at and say, how do we operationalize these concepts? Okay, similar story for the limit use of sensitive personal information as far as, the methods of receiving requests. Again, directing your attention down to the last portion here, that again, the use of a tool regarding cookies is not itself an acceptable method for submitting requests to limit. So yeah, I mean, all the service providers out there with cookie management tools are going to be obviously looking at these issues very closely and trying to dive in. But again, these concepts are not something that you find in the CPRA text itself about cookie management tools. It's the agency is trying to operationalize it. And again, it's a lot of making comments. Processing the request, this is basically the same as opting out of sales/share. And again, confirming the request, you're going to have to confirm that you processed the sensitive personal information request. And there is this suggestion of this day about using toggle radio buttons, right, to tell people that you've processed their request. So again, more sort of noise in the system here, for lack of a better phrase. So opt-out preference signals, we tease it the entire time. We're getting it to it in the last 4 minutes of our conversation, but this is sort of bearing the lead here. They are making opt-out preference signals mandatory. There is a big debate about whether the CPRA makes it optional or whether it's mandatory. Frankly, my reading of it is it's optional. I know that there are people who it's mandatory, and it's always been optional. The fact there is, debate over this is actually notable to me because you could have just said it in the text, right? Kind of anything process for the kind of tease out what this is then is this concept is basically what they're right. So businesses always need to recognize the opt-out signal. Businesses have a choice whether to process the opt-out signal in a frictionless or non-frictionless manner. If it's frictionless, then they don't have to provide the opt-out links, subject to a number of other requirements. If it's non-frictionless, then they still have to provide the opt-out links, okay? So what is friction? They define friction here. And you're not going to find, by the way, you're not going to find friction in the CPRA. This just doesn't exist. This is a new concept they've come up with. But frictionless, that means the business cannot charge fees, it can't change the experience, and it can't display notices in response to one of these best signals. Again, all of this is going to be subject to comment period. This is really new ground that they're covering, and certainly I can imagine that many people are spending their time already for this and trying out how to parse this out and make comments. The additional requirements, there's privacy policy disclosures. If you want to go this route, you'd have to describe it in the privacy policy. You'd have to your process in a frictionless manner. I think there's some issues there about how to consumer that means necessarily, and it has to be a full opt. When you're offline information, then it has to be full opt-out. It's likely right. So there's going to be limitations to this. Really, again, just okay. Let me turn it back over to Michelle to talk about service providers. I know we're short on time. We'll kind of wrap up that.
Yep, so just quickly, the CPRA created a new category of persons, contractors, and the sections 7050 through 53 clarify who are considered a service provider, contractor, or third party, and then provide certain requirements for those specific parties. So just briefly, the CPRA requires that all transfers of PI from a business to a service provider, contractor, or third party requires a contract. And like I said, those sections will lay out those contractual requirements. It is important to note that failure to have a service provider or contractor contract in place then means that the transfer is a sale. And so you're going to have those requirements to meet. There is a new due diligence requirement where I'm not going to read the whole paragraph since we're running short on time, but basically a business needs to conduct due diligence of its service providers and contractors. And if a business is never enforcing the terms of a contract or exercising any of its rights, then they can't really use the defense that they didn't know that the service provider or contractor was intending to use the PI in violation of the CCPA. And so this requirement covers service providers, contractors, and third parties. And so I'm going to pass it back to Dave to wrap up on investigations and enforcement.
Yeah, thanks, Shelby, and apologies again for my signal going in and out here. I'm not quite sure. It seems to be an issue with the time, so I'm not going to get into investigations and enforcement. It's there. We wrote an article on this as well, and it's here in the text if you want to take a look at it. I want to be respectful of everybody's time. What I will say is, if you're not already subscribed to our blog, we encourage you to do so. We try to keep people updated, and I always call this the shameless plug portion of our webinars. But we like to keep people updated and push out content that we think is appealing to you. With that, I would like to thank you, and if you're still with us a minute after, again, apologies for the audio issues, but thank you for attending, and really look forward to seeing you in our next webinar. Thanks.